Well, hello, everybody. This is another edition of Zoom Landlord Tenant Talk Radio, coming to you today at 5 p.m. Now, our normal time is always 3 p.m., but those pesky Lakers, they needed me today in that victory over the Cleveland Cavaliers. So I put on our show a little bit later as opposed to canceling. But next week, as we know, I'll be back at 3 p.m. So I appreciate you guys coming in a little bit later today. The topic of today will be the new lease that I have on my website. I have to give a big shout out to one of our normal regular listeners, which is Dina, who's in our room now. She kept chiding me to update my lease, and finally I got around to doing it. So I do appreciate Dina for giving me that little bit of a kick in the ass to get it going. But I do have that up on my website. And I did want to talk about it today a little bit. So I want to show you guys where it is and why I think that it really is a great lease and why you guys should be using it. So I'm going to share the screen now. And if you go to my website, which you should be able to see right now, which is evict123.com, you're going to get to the homepage of my website. And if you meander down right there, and I'm sure you can see that where it's in yellow now, free landlord forms. And if you click on that, that's going to bring you to our free form page. You might notice that right here in at the top, it's join our mailing list. This way you'll get all of our newsletters with new laws and new ways that our public officials are trying to screw us, which is of course what they're doing at every step of the way. So join that and you'll get the latest updates on what's going on in landlord tenant law and for income property owners. But if you do come down a little bit, you're going to see our new residential lease. I have a bunch of forms here, but this is our new lease. I'm going to click on that. It brings us to this. Then, so why do I think this lease is really the best residential lease on the planet for a landlord? If you're a tenant, you'd be crazy to sign this lease, but of course, we're dealing only with landlords. So why do I believe this is the best lease on the planet? And the reason is that, number one, it's in total compliance with all of California laws. But what it also does, it gives landlords every advantage that they can possibly have when tenants do crazy things on your property, or if you're looking for an exit strategy to get rid of a tenant, there's many things in here that a tenant will do which will have the possibility of being able to terminate the tenancy because they have violated a particular term in this. I'm going to go over this in a second, but I did want to say that the initial song today was I Got a Name. It was written by a guy by the name of Jim Croce. It was also featured in one of my favorite movies, which was Django Unchained, written by Quentin Tarantino. And I love that song and I love that movie. So if you were curious as to where that song came from, I Got a Name. Again, it was by Jim Croce. But going to my lease, the standard terms, of course, the rental amount and the term of the lease, which you could either do month to month, which I'm recommending. Don't do one-year leases anymore for a multitude of reasons, including the reason that if you only rent on the basis of month to month, then you can literally reject Section 8 tenants if you don't want a Section 8 tenant, because Section 8 will only apply to those tenancies where the landlord is offering a one-year lease. So if you don't want a Section 8 tenant and your parameters for leasing to anybody and everybody is only month to month, you'll be able to be rejected by Section 8. So if you don't want a Section 8 tenant, that's the way to do it. I do want to drop down to paragraph 6. Paragraph 6 deals with the issue of subrenting your unit. I normally don't go on subrenting. I usually normally go on unauthorized occupants, which is an easier way to do it. But sometimes you have a situation where people are using your premises by doing Airbnb or other short-term rentals. And the problem with that is if they're doing it, the issue is how do you prove it? Because you can't get the occupants who lease the premises on a short-term basis to come to court with you. So we always have that problem of how do I prove it when someone's doing an Airbnb? If you have it where you say, well, I see the advertisement, but if you say you see the advertisement, that doesn't prove that they're leasing it out. It only proves that they're advertising it. So we've had in the past where I've told clients to have a friend lease the apartment on a short-term basis for a couple of 3 days, and then we would use that person to come to court to prove it. But what I put in this subletting provision is not only you can't agree to assign or sublet, but you also can't advertise. So if you look there, I have actually that word that you can't advertise to subrent it. That would be a violation of the agreement. So these are the types of things that I've put into my agreement, which gives landlords more power. Listen, if the tenant's a great tenant, God bless you. But if you're looking for an exit strategy for this tenant and you can find out that the tenant is doing something wrong, then I've got a bunch of things in here. For example, in the parking section under section 8, I have it where you're not allowed to put anything in that parking space other than a registered vehicle, properly registered and operational vehicle that's registered to the tenant. So the tenant can't let anybody else park there. It has to be a vehicle that's operational. So if it's an operable vehicle, we'd be able to evict for that. And also that it has to be properly tagged. So maybe you don't care whether the tenant has a registered vehicle or not. It doesn't affect you. But if you're looking for an exit strategy and the tenant is parking a vehicle on your property that's not registered, this would be a ground that you could use to evict your tenant based on this lease. Moving down to paragraph 10, deals with alterations to the property. I purposely put in there not only that you can't alter the property without the landlord's written consent, but I also wrote specifically that you can't bring in a washer or dryer, which a lot of tenants do, or you can't change the locks. I specifically use those terms so that if the tenant changes the locks or bring in a washer and dryer, we have the right to evict. Moving down to paragraph 11, I talk about late charges. Most late charges in most standard rental agreements are not in accordance with California law. You have to have certain language, which I have in mind. And that again is under paragraph 11. It also states that if you're not paying your rent within 5 days of the due date, then you will, actually it's 3 days of the due date, you're going to be assessed a $50 penalty. That will be accurate and allowable to be charged under the newest California laws. But I also put something else into that provision. I put in, if you have to serve your tenant with a 3-day notice, that's like a lot of work on your part. In the city of Los Angeles, not only do you have to fill out a 3-day notice and deliver it to the tenant, you also have to file it with the city. So I put a paragraph in this provision, which is legal, that says if I am forced to serve a 3-day notice on you, forget the late charge, which I'm also entitled to, I'm entitled to $50 for the labor that I had to expend by preparing a notice, serving a notice, and also sending it on to the city. In paragraph 12, we talk about nuisance behavior, and I specifically have a phrase in there that talks about no smoking. Every rental agreement should have a provision, no smoking anywhere on the property. Now, maybe you don't care if somebody smokes. I don't care if somebody smokes, but you're going to have every other tenant who's complaining about it. And you have to have a way of saying, hey, that's a violation of your contract by having a smoking provision. So again, it's another issue that we can use in order to evict our tenants. Another important one goes down to paragraph 17, where we talk about that the tenant must have insurance. Now, you can't evict if the tenant doesn't have insurance because California courts have held that that's not a substantial breach of the rental agreement. But when there's a flood in your unit, for example, and all of his personal property is destroyed, if you have this paragraph in your rental agreement, it states that you cannot hold the landlord liable for destruction of your personal property. You have to have insurance, and that insurance has to cover that. So you can see that landlord cannot be sued for any damage to the tenant's personal property that was damaged through no fault of the tenant. Also, I have in there another thing. Let's pretend that you have to tent your buildings for termites, or there is a flood and the tenant has to temporarily locate. And the tenant, of course, is looking for relocation for that being temporarily displaced. This paragraph states that, hey, if you have to temporarily vacate my unit, you have to be compensated only by your insurance by your insurance policy. So again, it's shifting all liability from the landlord, which we like, back to the tenant, because if the tenant didn't have insurance or doesn't have the right insurance, they can't come after you. Paragraph 25 deals with the fact that if the tenant's trying to sue you, not for, if anybody's trying to sue each other for personal injuries, that they have to go through an arbitration process. That will, again, save the landlord thousands and thousands of dollars in litigation costs. Also, I have it where if a tenant vacates the unit in paragraph 27 and leaves personal property behind, normally you would have to go through a procedure called abandonment of personal property. This paragraph indicates if you vacate and you leave something behind, I can throw it out immediately or I can put it in my dining room. So it states that that personal property is totally considered abandoned the second the tenant gives you possession of the premises. And the last notable one in here that I like talking about is on the application. Many times you're going to rent to a tenant, and we had this in one horrific case where the tenant lied on his application, and then you guys didn't check it out close enough. And then what we had to do was you gave him the unit, you signed a rental agreement, and now he's in. And then the tenant becomes just the biggest nuisance on the planet to you, but not enough to evict on any straight violation. So I have in this paragraph dealing with paragraph 29, dealing with applications, that every statement that you made in your application has to be true. And if there's any fraudulent statements in that application, then that's considered a non-curable breach of the rental agreement, and we get to declare that you are in violation and to evict you. So that's under that paragraph 29 application. So these are the reasons why I believe that the rental agreement really gives the landlord the best power in the world to have an exit strategy. Again, it's in total compliance with California law. It will protect you on all of the normal things that every lease protects you on. But if you're looking for an exit strategy to get rid of a tenant who's just a gnaw in your side there, then this would be the way to do it. Okay, that's going to end our discussion. I do want to let you know that if you do want to talk to me, please electronically raise your hand. I see there are a few people now. It looks like I've got room for more people to electronically raise your hand. It's usually on the toolbar on the bottom of your screen. Just click on raise hand and I'll be able to talk to you. Again, this broadcast is for informational purposes only. It's not a substitute for legal advice. And last but not least, if you got a case with my firm, God bless you, but I don't want to specifically talk about any specific case. This Zoom meeting is for general information only. And with that, I'm going to open it up to Dina, who is so insightful in terms of telling me to get this rental agreement prepared. And so I did. Hello, Dina.
Hi, Dennis. Many thanks for this awesome lease because I went through it. And I want to say it's really good, but it's also different than other leases that highlight for the tenant their responsibilities rather than only their rights. And this is what your lease stands out for. Even the real estate agent, she said it's better than the MLS. It's so concise, to the point, and all that. But there is one thing technical. I think on provision 25, it wouldn't let me check it unless we print it out and check it. We're saying the, what do you call it? The property is exempt. I just want to mention it.
I might have to change that. I don't know that it's in 25.
No, 35, I think. Am I right? And I don't know. I think so.
You know, you're right. I will fix that. Well, of course, once you print it, you can always make a check
Yeah.
there.
Yeah.
You're right. I see that needs a little help, and I will take care of
That's
that.
awesome.
Maybe
Awesome. Thank you.
tomorrow.
Thank you for it. I have one quick question. And again, thank you for mentioning last time about, I think, the 602 for the squatters. And I contacted the local authorities, which is the city and the police, and they say they have a form. I think they call it letter of agency, where we can fill more than one property, even the home, if you're vacant or something, and for 6 months, and they come and do it. So thank you for mentioning that, because I check it. But I have one question on that, which they recommend the same, that what you recommend, that we put security cameras. But here's my question. If we put, and then the unit, we're renting it, and then the unit is not going to be vacant anymore, wouldn't that be, the tenant will come back and say, this is invading my privacy, you have a camera on the door of, then we have to spend money installing it and then spend money of taking it out. So what's your thoughts on that, Dennis?
Well, I'm just saying that to temporarily put up cameras, and also my thought wasn't exactly cameras, it was hiring a security company that would not only protect the property, but also have an armed response. I mean, it's just one way to protect yourself, so that we've heard in the news that these marauders are just breaking into places and then pretending to be a tenant and showing a phony lease, like they get my lease online, like you guys can do so. So
then
I
we might
think,
go, with a portable camera better, and put it in the window, maybe from the inside. And when the tenants, they come in, we can take it out. How about
yes,
that?
of course, but I still like, if you're concerned about this, and trust me, this is just rampant now. People are breaking into vacant units. So any way you can do to protect yourself. But anyway, Dina, thank you very much. And we're going to move on to Jim Polina. Say hello by unmuting yourself.
Hey, Dennis, how's it going?
It's good, Jim. How are you, sir?
I'm doing good. I've got a question for you, and this almost happened to me, but I don't know how to take care of it. So I had a party sign the lease. I went over it word by word. They gave me a security deposit, paid in full, but then they were unable to pay first month's rent in full. So I didn't rent it to them, and I lost rent because I had to go advertise it again. Could I have just deducted lost daily rent from the money that they paid me?
Did they sign a rental agreement?
They did.
If they signed a rental agreement, then you can deduct for the time that you had it off the market, because technically they're liable for the full rental agreement at that point.
Okay, that's what I thought. Okay. Now I do have a second question here. Has to do with the Just Cause Ordinance and the RSO. And I'm a little confused on this, because the Just Cause deals with buildings built after 1978, and the RSO is buildings built before 1978. Do I have that correct?
It's the actual date is October 1st, 1978. If it was built that date or after, it's under the Just Cause Ordinance. If it was built prior to that date, it's under RSO. However, single-family homes have never been under RSO. So even if it was built in 1940 and you have a single-family home with only one house on the lot, then that would still be under JCO, the Just Cause Ordinance.
And just how strictly do people or attorneys abide by these dates? Are they critical?
Well, I mean, if you're bringing forth a lawsuit and for example, and your property was built in 1972 and you didn't register your unit, you're going to lose your case. As simple as that.
Okay, so they are pretty important then, the dates.
Yes.
Okay. Thank you, Dennis.
All right, you take care. Okay, let's see. Bear with me 1 second because I hit the wrong button here. Okay, let's move on to DC. I'm going to ask you to unmute yourself.
Okay.
Hello, DC.
Yeah. Hello, Dennis.
And you're the loyal person who goes to all the trade shows that I always see you on.
Yes, I've seen you over there. I see you all the shows. Anyway, we have to give the tenants the RSO certificate, a copy, and we send it in the mail or we give it to them either way. And the same thing when it's a single family home, we have to give it to, we have to give them the piece of paper saying this is not under rent control. And so what, in case of an eviction, the tenants are going to say, "Oh, I never received that." Or so. Do you have cases where the tenant says they did receive it, but they're just going to say, "I never received it"? I
Well,
don't have-
anybody, well, you know, the tenant can also say, I never got the 3-day notice to pay rent or quit. It's always the same story. But as long as you say you mailed it, in most cases, we're not going to have a problem with that.
Oh, okay. And the same thing with a single family home saying it's not under rent control.
Well, there's nothing to mail to them on are we talking about the city of Los Angeles?
Well, actually, all single family homes in the United States, oh, no, in California, the ones that say this is not under rent control, single family.
Correct.
homes.
Correct. You have to serve them or have contained in the lease that this property is not subject to statewide rent control. And again, I have that in my rental agreement. But it's the funny thing is that there's another law which I've talked about called Costa-Hawkins. And even if you neglected to put that phrase in your rental agreement, nothing prevents you from raising the rent to market value. You might not be able to just serve a notice to terminate the tenancy because you'd have to have just cause because you are subject to statewide rent control, but you're not subject to rent limitations. Any single family home, condominium, or townhouse, whether you have that phrase or whether you don't have that phrase, whether it was built in 1942 or built in 2010, you can raise the rent to whatever you like.
Oh, okay. So that won't be an issue that if it's an old lease, the new ones are, okay, that already has it in there,
Yeah,
but the old ones that don't,
Well, then you have on my website, we have
the
in
form,
fact,
yes, but the form,
have-
I send it in the mail. I send it in
Right.
the mail and they're gonna say, I never got that.
well, okay, well, if you're really that concerned, which I don't really see as an issue, then you can always send it with a proof of mailing. And now
Oh, okay.
it costs you 15 cents, but the post office maybe a little bit more now, but then just proof of mailing, I mailed it to you and nobody's going to argue about it. Anyway,
Oh.
thank you very much. I'm going to now move over to Rick R. Say hello by unmuting yourself, sir.
Hello, Dennis.
Hello.
I'm going to put in a plug for you. You recently settled a case for me, the one in Pear Blossom, and I didn't have to go to a jury trial. So thank you for that.
My pleasure.
I want to follow up a little on what Dina was talking about, because in a couple months, this property, it's up in the hills in the Antelope Valley. It's about 20 minutes from any police department. I wanted to talk more about the armed response that security companies have. Are these companies like ADT or
Yeah,
they're separate?
almost all of them have that, from Bay Alarm to ADT. It's going to cost you another $80, but you're only doing it for the time period while the premises is vacant. And the reason why I'm saying to do that, in addition to filing it with the local police department, I mean, that certainly is a proper thing to do. But this is just rampant and the politicians don't care about it. I tweeted this last week that maybe what we should do is invade one of the politicians' homes, and then maybe they'd get off their ass and start caring about God-fearing people who own real estate and pay real estate taxes to the county. Maybe they would do something then if we invaded their homes and just sat there and then let them see the position. But
Amen.
But again, the better thing is if you have an alarm on your house and the alarm company calls the police, God only knows when they're going to get there, and depending on what jurisdiction you're in. I know in Los Angeles, good luck, 2 hours later or something maybe. But if you have an armed response from the company and it's going to cost you another $70, $80, they're going to be there really quick. And they're going to size up the situation as the guy's trying to crawl through a window, and set off the alarm. So I just think that's a good thing to do. Now, if you live on the property and you're renting out one of the units and that's vacant, okay, fine. But if you've got a single family home and you're going over there, and this property probably is pretty far from where you actually are,
Yeah,
I would definitely have it alarmed because these people are like cockroaches. They're just jumping into your place.
yeah, I know. Thank you.
All right, Rick, nice talking with you. Okay, moving along, we are going to go to Paul Dia.
Hi, Dennis.
Hey, how
Thank
are
you
you,
for taking my
sir?
question. I'm doing well, thanks. I'm a previous client of yours. My father recently passed away and will be inheriting his primary residence. He had a friend who was renting a room from him, and there doesn't appear to be a rental agreement in place. They're attempting to pay rent to me right now. If we don't intend to have that person continue renting, what are our best next steps?
Well, the first question, as always, is what city is the property located in?
Los Angeles.
Is this a single family home with only one house on the lot?
Yes.
Okay, more likely than not, this person is a proper tenant, was probably paying rent to your dad, and your dad probably didn't have a rental agreement. That's probably the scenario, correct?
Yes.
So number one, you can't just ask a tenant to move. What do you intend? For no reason, you're going to have just cause, because every residential unit in the city of Los Angeles requires just cause to move. So why do you want the tenant to move?
Sorry, this is Paul's wife. It's actually my father who recently passed, and we intend to make it into 2 units and make it into 2 rental units because it is in a zone that allows that, and it would just help us, financially. We do have the
Are
ability.
you intending to move in?
No.
Okay, so you're going to make it into 2 units. So this would really be under the Ellis Act because you're going to be permanently removing that 1 unit forever from rental housing use, because that 1 unit will not exist anymore. So you'd have to go through the Ellis Act to evict this person from this single family home, which you have the right to do. Another way to do it would be to just raise the rent. It's a single family home. It's not subject to any rent control. So we could just raise the rent, and by raising the rent, I'm sure that this tenant will leave. And there's no limitation on what you can do. So I'm sure the guy's not paying much because he was only renting a room, but now he's got the whole house to himself. I mean, he always had the whole house, but he was renting 1 room and had use of the kitchen and living room and everything else, I presume. So on that basis, you should just raise the rent. If you're going to raise the rent above 10%, you're going to need to serve a 90-day notice.
Okay.
It's probably the easiest way. Or we can go the Ellis Act, which seems a little extreme.
Okay. Thank you. At least we know we have some options. And is the next step also not to accept the rent that they're trying to pay us for this month?
You might as well accept the rent. They're proper tenants. Take the rent. How much is the rent, for example?
I'm not 100% sure. I might have heard an amount from my dad say like $800.
Great. Take the $800. It'll defer some of the legal costs. And we'll just raise the rent for you. If you want us to do that, just give us a call.
Got
Thank
it.
you.
Thank you so much.
Okay, so we are moving on to one of our regulars, Harold. Say hello.
Right, Dennis. All right. Just want to plug the Lakers, man. Looks like we're doing good.
Well, I think we've won 9 out of the last 10.
Yes.
We just leapfrogged over Sacramento, the Sacramento Kings.
Mhm.
So I think we're now in the 8th spot, which is pretty good. And with a little luck this weekend, we could get up to 7.
Love it. Okay, so I have a 2-part question. It's a pretty easy question. I had a contract with the tenant that did start out as a 6-month lease, but many years ago it converted to month. Is there a concern? Because you always say do these leases that are month to month. It is month to month now because that's just part of the contract. Yeah, I mean,
Right.
or it doesn't mean anything. So I don't have to worry about that. The other part is, are you ever allowed to get the difference? And the original rent was a lot cheaper than the original rent was a lot cheaper. So the last month was a lot cheaper. Can I see if I can make up the difference, the current rent,
Okay,
or you can't do that?
well, there is no such thing as a last month's rent deposit. It's considered a security deposit.
Ah.
can you raise the security deposit? First of all, what jurisdiction are we talking about?
LA Just Cause.
The answer is no, you cannot. Whatever, the only thing you can do for LA would be to raise the rent, to raise the security deposit at the same time when you're raising the rent, which this year was 4%, you can raise the security deposit 4%. Otherwise, you cannot get it up to what it properly is at this point. They've written that out of the law, and the city council wrote that out of the law because of Dennis Block, because we were throwing people out during the pandemic. When the tenant wouldn't pay the rent, what we would do is, if the tenant had only paid when they moved in a 1-month security, what we would do is we would serve a 30-day notice increasing the security deposit to the maximum allowed by law, 2 months rent. At least that's what it is now until July. And when the tenant wouldn't come up with the additional month of security, we would serve them not with a notice to pay rent or quit. We would serve them with a notice to perform or quit. And if they didn't pay, we evicted them. We evicted about 300 people for happy clients where these, I don't want to use that word, but where these tenants were not paying rent, even though it had nothing to do with COVID. We found a way to evict 300 people during the pandemic based on failing to pay the additional security deposit. Well, the city council, what they do is, I think they listen to these broadcasts and read my columns. So they wrote that out of the new law. So all you can do now is raise the security deposit when you raise the rent the same percentage.
Hey, but real quick, if it's owner occupied in a single family residence and I can do it up to market rate, I can do the security deposit up to market rate?
No,
Whatever.
not the security, only the rent.
Okay,
They have nothing to do with the rent because that's under Costa-Hawkins.
got it.
Anyway, Harold, thank you very much. Appreciate your loyalty. We are moving on to an owner by the name of Audrey Smith. Audrey Smith, I'm going to ask you to unmute yourself. Hello, Audrey.
Hello?
Hey, there you go.
Yeah, I
Smiley
got it.
face.
So my concern is we have a Section 8 tenant
Yes.
who's in LA. She does pay her portion of the rent. However, she doesn't live there. So she hasn't lived there maybe 5 to 7 years. And we had a bad fire there about a year ago because people were, messing around the place. So my question is, she can't go up the stairs, it's upstairs. So how can we get out? How can we evict her? She's a Section 8 person in LA.
Is anyone living there?
No.
So she doesn't really occupy the property. So does
Right.
she ever go there? She using it for storage? What is she doing with it?
She does have a little in storage, but not that much. She just want to maintain her Section 8 voucher.
Okay, so what I would do, and again, what city? This is Los Angeles, right?
Yes,
And this is an apartment, correct?
yes.
Okay, so what I would do is I would contact your Section 8 advisor and say, look, this tenant's not living there. You're paying me and you're wasting government money on the basis that the tenant really doesn't live in this unit. We need you to go check this out. And they'll knock her off of Section 8. When they knock her off of Section 8, that means that she's responsible for the full rent, which of course she won't want to do. That will be your exit strategy.
Okay, thank you.
You're very welcome. Good question. Okay, let's move on to another client of mine, Michael and Sarah. I'm going to ask you to unmute yourself.
Oh, hi, Dennis. How
Hello,
are you?
Michael. I'm good.
How was your day, your game day at the
Well,
Lakers
I'm
game today?
Proud to tell you we won by about, 18 points today. I actually left a little early. I didn't see the streamers coming down.
Oh,
And I went with my son, and he had a friend that came, and I told him that when we were having a little lunch before the game, I said to him, did you bring your binoculars? Because we're up in the nosebleed seats. He says, no, I didn't. I said, well, sorry, you'll see how good your eyesight is. Well, of course, my seats are right behind the Lakers bench. So he was
wonderful. Go
was-
Lakers.
Yeah, so he was pretty surprised. In fact, my seat is, though she wasn't there today, I sit next with a hand of where Michael LeBron's wife is.
Oh,
So-
wow. Yeah,
so
right in
anyway,
the front.
But anyway, I had a good game today.
Yeah,
and,
wonderful.
And that's why we're doing it a little late. So I do appreciate everybody
Right,
coming out a
right.
little later. I still think 3 o'clock is the best time. Certainly for me, it is.
Yeah,
So, and next week it will be at 3 p.m.
3 p.m.
Unless something happens.
Oh,
So
okay.
stay tuned. But anyway, Michael, what's your
Okay.
question?
Yeah, the question is, we have one tenant that has a lease agreement, but there is no late fee clause checked on it. Now, can I unilaterally send them a letter that, as effective, immediately, if he doesn't pay after 3 days or 5 days, there's going to be a late fee.
What city, please?
That's in LA.
Is this an apartment or a house?
Single, yeah. Actually, it's a front house and a ADU in the back.
So that means you're under LA rent control for the front house, and you can't change the terms of that tenancy because you're under LA rent control.
Oh, okay. So,
So you're stuck, my friend.
oh, I see.
Next time, you know what to do. Go to that website, evict123.com, and download that lease, because I really think that that lease just gives landlords a lot more power and still being in compliance with the law. And with that, I am going to move on. Let's move on to Sam. Sam, I'm going to ask you to unmute yourself. Sam Shabbat.
Yes, thank you, Dennis. I have a question. Can you discuss Ariata claimants and the consequences of failing to serve the prejudgment claim of right to possession to flush out or smoke out the Ariata claimants when you're doing a UD?
All right. So for everybody, let me explain what Sam is talking about. So 100 years ago, when I first started practicing law back in 1977, I got sworn in December of 76. And within a couple of years, there was a case called Arietta. And what this case was about, and I'll tell you the concept of it. By the way, Sam, no yawning, okay? No, I'm just kidding with you. So the concept was that the landlord wasn't getting his rent, and he had a husband and wife, Mr. Arietta and Mrs. Arietta. And so what he did was he sued Mr. Arietta, and he won the case. And the sheriff was going to do a lockout. And then Mrs. Arietta said, hey, wait a second. I'm a proper tenant here. You never sued me, and yet I'm getting evicted. And maybe I had something to say. If I had been sued, maybe I would have gone into court and I would have said I paid the rent, even though we didn't, but I could have. And I don't have it. I'm getting dispossessed on the basis that I wasn't sued, so I had no voice in court to complain or say something. So the court said, well, we're going to grant you the right to, and it's unbelievable. What jurisdiction other than moronic California will allow somebody to be a defendant? Who would want to be a defendant? You want to be a plaintiff. I want to sue this person. But who says, please, I want to be a defendant. I want to be sued. Well, only in California. They allow people to jump into your lawsuit as a defendant so that they can claim that they have a right to possess the premises and therefore they need their day in court. So this case came about called Arietta, an Arietta claimant, and sort of prejudgment claimant. So the way they set this up is that when you serve your initial lawsuit, you serve it with this prejudgment claimant forms. And if somebody wants to jump into the lawsuit, they got to do it at the beginning of the lawsuit. But if you don't file this prejudgment claimant form and give them an opportunity to jump in at the beginning, then when the sheriff's doing the lockout, or right as they're doing the lockout or before, they can file this prejudgment right to possession saying, hey, I live here. I haven't been sued. I have a right to possess this property. And if that happens, then the sheriff will not do the eviction. You'll have to have a court appearance where the court will determine whether this Arietta claimant or prejudgment claimant has a right to remain in possession of the property. So in our cases, for example, every single case we file for prejudgment protection so that they can't do this at the end of the case, because they will do it. The only problem with that is that if there is a if you can't serve your tenant and you have to do it by an alternate procedure called an order to post, then you can't get prejudgment protection. So this will sometimes happen in our cases where we couldn't serve the tenant. He's evading service. He won't open up the door. We go in on what they call an order to post, which allows us to serve him by just posting it on the door, but you can't get the Arietta protection. So again, if you have to go to an Arietta claimant hearing, you're going to go there as the landlord. You're going to say, look, my rental agreement says that only A and B can live there. I don't know who this C person is. I've never taken any rent from him. He has no right to be there. So I think that's pretty well the topic on prejudgment claimants. Sam, did you have any other questions on that? Oh, you still there, Sam? I'm going to ask you to unmute, Sam. There you
Oh,
go.
yeah. Yeah. Does it differ based upon being in the city of Los Angeles, say for the city of Bell, for example?
No, there is no difference. This is a state law dealing with the right of somebody to claim. Now, since this poor Mrs. Arietta had the right to jump into a lawsuit, every single Arietta claimant from the beginning of time till now is all fraudulent. So this quote, do good law to allow Mrs. Arietta the right to say whatever she wanted. And maybe that was the one and only legitimate case, the one and only. There has been hundreds of thousands of Arietta claimants filed in unlawful detainer cases to delay their procedures. So it's one of those do good laws that only hurts every landlord and is only a way for tenants to commit fraud upon their landlords.
Thank you.
Okay, thanks, Sam.
Thank you.
Well, that was kind of a long explanation. I hope I didn't bore too many of you, but it is an issue that does come up, and our firm does try to file in every single case where we legally can that protection. Let's move on to Suzette. Suzette, say hello. Suzette, unmute.
Hello,
There you go.
Hello, Mr. Block.
Hey, are you driving?
No, I'm parked in the garage.
You are.
Yeah, I'm not moving anymore.
Okay, is your doors locked? I don't want you, vandalized right now.
No, I won't be vandalized. Okay, so I have two questions. The first question is, when you successfully evict your tenant, how can you get that eviction put like on their record or their credit report? Can you do that?
You can, if you obtain a judgment within the first 60 days from the filing of the lawsuit, then under state law, it has to go onto their record as an eviction on their record where any other landlord can check. And if you check the case number on the court docket, you'll actually see it. But in a lot of cases, you can't get a judgment within 60 days. Either the courts are slow or you couldn't serve the tenant. So you had to go through maybe an alternate method. So if that happens, and you get your judgment, he's rightfully evicted. He's certainly guilty of unlawful detainer. He certainly was a tenant who didn't pay his rent on time. But since the judgment, and this is crazy laws, but since the judgment wasn't obtained, what's the basis of that within the first 60 days? Then every landlord cannot determine that this person was evicted 20 times before. So you can file a motion with the court, though it's a little bit costly. You have to file a motion with the court and attend a hearing where you can get the record unsealed. We charge for it like close to $1,000. Most landlords don't want to do it, so it becomes on their record. But it is what it is. So the legislature, the California legislature, what they're doing is they're empowering tenants to screw one landlord, and then once they get evicted, screw another landlord, and it just keeps going on and on and on again. It's just our do-good society. And maybe one day people will wake up and understand that the property rights should be supreme.
Okay, thank you. And then the second question is, if they leave their stuff in the unit, how long do they have like to get it out? Like if you schedule a time for them to pick it up, how long do you have to give them, like hours?
Okay,
Like,
did the sheriff do the lockout?
no, but it's going to be they're gonna probably do it next Wednesday.
Okay, if the sheriff does the lockout, you don't have to fill out any other paperwork, and the tenant has 15 days to retrieve his belongings. He has to make a one-time appointment with you at your convenience, but you want to make it convenient because you want to get this crap out of your unit, to pick up his stuff. If he's got a household full of furniture and he shows up without a truck, you can tell him, look, if you're not taking everything, I'm not letting you in. You have to grab everything. Otherwise, the rest of it's going to be considered abandoned. And if he doesn't get it at the end of the 15-day period, because this is only when the sheriff does the lockout, then you can toss the stuff away if it's worth less than $700. If it's worth more than $700, then you have to hold an auction. And I have a referral for that on my website. Actually, I don't have it on my website, but I have a referral if you call the office, and I'll give that to you. Now, if the tenants move and just left stuff behind, then number one, if you use my rental agreement, it says, I don't got to do nothing. I can just throw it all away.
Right.
But if you don't use my rental agreement, then you have to go through a procedure dealing with abandoned personal property. I have that form on my website. You fill out that form, you mail it to the tenant's last known address, which would probably be your property. And then in 18 days from the date of the mailing, you can toss it away if it's worth $700 or less, or if it's worth more than $700, then you have to hold a public auction.
Okay, thank you.
All right, darling, good questions. I'm going to move on now to Mark Dotson. I'm going to ask you to unmute yourself.
Hi, Dennis. Thanks for this call. I have a couple questions, and then it's the first time I've joined, so hopefully you're not repeating yourself. I have a Torrance PO triplex. The front house is was built in 1953 with a back duplex built in the 80s. So my first question is, does the RSO provision apply to the entire property, or just the one building that has was built before 1978?
Okay, so for the audience, when you say it's a Torrance PO, what you're saying is that if you write out the name of the city, you're going to write Torrance. But the truth is, it's really in the city of Los Angeles, just like they sometimes have a post office box, Beverly Hills, but you're really in Los Angeles. So yes, you are under RSO. The property that, as long as the units are separated, the unit that were built in the 80s are not under RSO. They're under JCO in terms of good cause to evict. And those back units are also under statewide rent control for how much you can increase the rent, which this year is 8.8%. The front house is under RSO, the Rent Stabilization Ordinance, because that was built prior to October 1st, 1978. So you have to register that unit with rent control, and you're only entitled to a 1-year increase. This year is 4%.
Got it. Now, separately, I have the tenant in the front house was a family that was living there when we bought the property. And so we have them on a 12-month lease that ends in June of this year, but they have been perpetually late in paying rent. When they do pay, they do pay it with the late fee that we charge. But they've also, we have a provision that they have to report repairs or damage or repairs. And they ended up having a leaking toilet that was not reported, and we pay the water, and it cost us thousands of dollars on our utility bill. I was just curious if we have any recourse to not extend their lease after June, when it expires in June.
The answer is no. The better strategy would be on May 2nd to serve them with a 3-day notice and pray that they don't pay within the 3 days. Otherwise, they are protected tenants, and that month-to-month tenancy, they can stay there until your grandchildren have grandchildren.
Okay.
Unless they do something wrong.
Well, I guess do something wrong as in?
Well, not pay the rent. So I would serve on, if you're saying they're paying their rent late every month, quickly serve a 3-day notice on May 2nd, the day after rent is due. And then you'll be able, if they don't pay within 3 days, we got them. You don't have to accept the rent beyond the third day.
Even if they notify us that they will be late in rent in that particular month?
And I'm going to notify my mortgage company. By the way, mortgage company, I'm not going to pay you for 60 days. See how that goes over.
Okay.
Thank you, Mark. Good questions. Okay, let's move over to beautiful Abigail. I'm going to ask you to unmute yourself.
Thank you so much, Dennis. I so appreciate your knowledge. I have been managing a property for my mom in Monterey Park. It's an unattached duplex. It's on a month-to-month lease. I did not know about Just Cause, and the home has been listed on the market for sale. How can I get them out? Can I give them a 60-day notice saying, I want to renovate the kitchen and bathroom? Do I need to take it off the market? What do I need to do to prove that I'm going to be renovating it? And I don't mind changing the countertops or, what I need to do to make the bathrooms look better.
Did you say this was Los Angeles?
It is actually in Monterey Park. It is not Los Angeles.
Okay, so Monterey Park, it's a single family residence. When did the tenants move in?
It is a duplex. They moved in April of
Oh.
2020.
Okay, so then you're under statewide rent control. You do have to have a reason to evict. The easiest reason is a renovation, but renovation is not changing countertops, my love. What renovation is, it's work that requires a building permit like an electrical or plumbing. It also requires that the premises be uninhabitable for at least a 30-day period. So you got to basically gut the kitchen and the bathroom or both or one or the other. And then if that's what you're intending to do and it's going to take longer than 30 days, then we can do that renovation eviction. You're going to need to pull a permit first, and you're going to have a contractor do a little statement of the work that's going to be done and why it's going to take longer than 30 days. Then we can serve on your tenant a 60-day notice to vacate based on renovation. We do have to pay relocation, which is equal to 1 month's rent, but it certainly is doable.
The renovation is my best bet, it sounds like.
I think so.
All right. And so that means I really have to do a project that's kind of
Well,
big.
you really have to do it or you're going to get sued. So
Okay.
obviously, let's think this out logically. You've got yourself a duplex, which is going to be worth infinitely more money if it's vacant than if it's occupied, right?
Right. Yeah.
So whatever you're going to spend on this kitchen and bathroom, 20,000, you're going to get that back in spades.
Love
And
it.
also the place is going to look better. So all around, it makes sense to get rid of these people.
Okay. So I can send that 60-day notice tomorrow if I wanted to.
The answer is no, you can't.
I got to get the permit.
You have to have the
first.
plans in place. You have to have your permits pulled, and it's a special notice that an attorney needs to prepare. And I happen to know one who could do it properly.
I think you do. All right. Thank you so much.
Okay, Abigail. Moving along too, and our time is we're doing pretty good today, and the show is moving. Jonathan Kennedy, I'm going to ask you to unmute yourself. Any relation to former presidents?
No, I don't have a trust fund.
In other words, you have to work for a living?
Yeah, I do.
Bummer.
Hey, I was very interested to hear you talk about the way to avoid Section 8 contracts by only accepting month-to-month tenancies. That was
Yes.
at the trade show.
Yeah, across the board, you're not doing it for Section 8, doing everybody, advertise it, we only do month to month. But there's also other reasons to do it. For JCO property in Los Angeles, if your tenant has been there less than 6 months, you have the right to serve a 30-day notice. If your property is subject to statewide rent control, you can get rid of a bad tenant if they've been there less than 1 year. But if they're on a 1-year lease, you're stuck.
Okay. Well, I've thought about this other idea for many years, and I wondered what your take on it would be. And that would be to go ahead and accept your Section 8, an application from your Section 8 tenant. Just treat them like any other tenant if they qualify, whatever. Just go through the process. And at whatever point in the process they ask you to sign that HAP contract, just say, no, I don't want to, I'm not signing that. What do you think would happen?
Well, the reality is state law requires a landlord to accept a Section 8 tenant. So you could get sued as a violation of the state law for discrimination and in violation of that law. So I don't think that's a good idea.
But they can actually force you to sign a contract?
Absolutely. They're saying you have to take a Section 8 tenant. So you list your property and you state what you want for it, the amount of rent. If Section 8 doesn't want to pay that, then you don't have to deal with Section 8. But your position is if you don't want a Section 8 tenant, and I recommend this for everybody, just do month to month. I mean, I never suggested that in my entire career. I said, do a year's lease. There's no reason. You're not just suing these or going after these people anyway. So.
Yeah, okay, thanks.
Thank you, sir. Let's move on to, let's see. Let's move on to Mike Wynn. Mike Wynn, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hey, how are you?
Been a long time listener for and actually I have the pleasure of meeting you in the AOA in Long Beach. And previously my tenant was the 8 years and he moved on, right? And so I contacted you and you such a pleasure, bring such comfort. I never had to dealt with like bad tenant. So this is the second guy that came onto the unit that I had rented out. So from day one, he keep on being late, and I didn't really understand how to deal with it, but I think I get the hang of it now that after listening to all the talk that you've been given, the day after he's late, issue that 3 days notice, right? And so my question is, I don't think I want to keep him long term. So he have until August, to complete the lease. I have to serve him a 90 days notice, bump up the rent way high, so that way it's become completely unaffordable to him.
Okay, what city is this?
City of Irvine.
Okay, so you're in Irvine, a civilized place to own property since they don't have local rent control. And is this an apartment or a house?
It's a house.
Okay, is he
single
on a
family home?
Is he on a 1-year lease?
He is.
Okay, so yeah, you can just bump up the rent. That would be one way. But if you're saying he's always late in the rent, why don't you just, like when I'm told the other gentleman, on May 2nd, serve a 3-day notice?
Okay, I will do that. I will do that.
All right.
Thank you,
there's a
Dennis.
little feedback in the background there. So thank you very
Yeah.
much. And I'm moving on to somebody who I'm really curious to talk to, ZZ Top, one of my favorite bands. Did you get that from the band or you just like ZZ?
Yeah, I got it from the band. Actually, my name is Zena, and I've called you many, many times early in the morning, and I've showed up to a few of your meetings. But
I appreciate that. You look way too young to even know ZZ Top back in the 60s and early 70s.
well, thank you very much. Okay, my question is, I'm just trying to wrap my head around how to word the fees. I notice a lot of people are talking about late fees. And when a tenant leaves and they still have an outstanding balance of late fees, and we're only allowed to get the rent, rent from the security deposit, how do we put the wording in our contract or
Very simple, and I have it in my contract. You are right that from a security deposit, you're only allowed to deduct for unusual wear and tear, cleaning, and rent owed, nothing else. However, if you look in my lease, it says any monetary obligation owed under this contract is considered rent. So based on any monetary, it's in my rental agreement, any monetary obligation owed under this contract is considered rent. If the tenant signed that contract, then guess what? Late fee, you owe me, that's rent, and I can now deduct it from my security deposit. So it's just another little trick that we use.
Okay. All right. So one last question. When a tenant abandons the property, because I put a notice in there to come in there and make some changes and find out if it was abandoned, and I noticed the key was on the counter.
Okay, what was on the counter? The key, did you
The
say?
key to the unit. The door was left open and
Okay,
Yeah.
so that would give you belief that he has abandoned the premises or vacated the unit. And at that point, that's when the time would start to run for the 21-day security deposit from when
Okay.
you found out.
perfect.
Okay, thank you. Ladies and gentlemen, it is 6 o'clock. We've done our 1 hour. I've got a party to go to. It's somebody's turning 65 and I got to dress up like an old man. I said, I don't have to dress up. I'm already an old man. And my wife is probably giving me a hard time if I don't get the hell out of here. So I want to appreciate everybody for coming in. Next week, it will be back at the normal time, which is 3 p.m. Appreciate everybody. And guys, have a great weekend and hope the Lakers win tomorrow because I'll be there too. Thank you, guys.